You survived the accident. Now what? We turned a life-changing injury into a $20 million recovery for a crane operator. When a crane operator got crushed on an offshore lift, insurance pushed low offers. We said no. We built a case that forced a responsible settlement and real justice for our client. He was working 60 miles offshore when a boom failure and bad procedures dumped a massive load onto the deck. He suffered catastrophic injuries, long hospital stay, surgeries, and lost future earning power. The employer paid maintenance and cure at first, then stalled, so we filed. We used 3 pillars: Jones Act negligence, unseaworthiness, and punitive damages tied to bad faith maintenance and cure denial. Under the Jones Act, seamen can sue employers for negligence. As of November 14, 2025, that protection is codified in 46 U.S.C. Section 30104. We documented unseaworthy conditions, faulty crane inspection logs, missing safety devices, and ignored warnings. The unseaworthiness doctrine holds owners strictly liable when vessel conditions cause injury. We also pressed maintenance and cure. The company's slow response allowed us to claim aggravated damages and fees. Maintenance and cure is a separate, immediate duty to pay living expenses and medical care. We drained their defenses with expert testimony, mechanical failure analysis, vocational life care planners, and a rehab economist. We subpoenaed inspection logs and internal emails. Then we used those documents at mediation to maximize leverage. After focused preparation, the carrier paid $20 million to avoid trial. That money covered medical care, lifetime support, lost earnings, and structured future care, plus accountability. Unverified. Confirm settlement public record if needed. If you or a loved one were hurt offshore, know your rights. Subscribe for a deep dive on Jones Act cases.